Well, welcome everybody to our new PNFS online talk, and I'm very pleased to welcome this evening Sheila Dillon, who is now a PNFS footpath inspector. Professionally, she was a lawyer working with Cheshire East in the planning department. So we're very pleased to have her expertise, for the benefit of her expertise this evening. And following Sheila, we will have Terry Norris, who will talk about the implications for Peak and Northern and Peak and Northern members, how we can make the most impact to intervene to protect footpaths when planning applications appear to threaten them. So first of all, over to you, Sheila.
About 30 minutes from me on the planning regime generally, before Terry talks over more specifically about PNFS. I'm going to look at three main ways in which that inaction occurs. Firstly, at strategic planning level, and this is where a council is allocating sites for new development in its local plans, and it's setting a policy framework for its planning decisions. Secondly, at planning application level, so this is where it's deciding whether or not to let development go ahead, and it's government policy that when it's deciding an application, the impact of development on a public right-of-way is a material planning consideration. And thirdly, I'm going to look at funding for public rights-of-way, because there are a couple of ways in which money can be forthcoming from developments, either through planning agreements, Section 106 agreements, or something called the Community Infrastructure Levy, or CIL. For preliminary points, whenever councils are acting in the planning regime or system, they'll be following rules set down for them in the Town and Country Planning Acts and regulations, in national and local policy, and in case law. Secondly, planning permission required to build on land. So, for example, to develop a new housing estate, or to extend an agricultural barn, or to carry out engineering operations, a new quarry, or even change the use of land, for example, from a field or a paddock to a residential garden. So the householders must get planning permission for that. Planning permissions granted or refused by local planning authorities, and who these are will differ throughout our wide and long area, according to whether you're in a shire county or you have a unitary council, such as Cheshire West. You have a metropolitan council around a big city, such as Sheffield, or if your land lies in the Peak District National Park. The fourth bedrock introductory point is that obtaining planning permission won't itself extinguish or divert public rights of way. Once you've got the planning permission, you need to go on and obtain a separate order. You may be familiar with Section 257 stopping or diversion orders, but planning permission is the preliminary step for that. So, strategic planning, an overview. Planning decisions have to be made in accordance with a development plan, unless material considerations indicate otherwise. So what is the development plan? Well, it can be a suite of documents that set out how much new development is needed, where it should go, and what the site requirements are. What are the criteria for saying yay or nay to development there? And those documents can range from, you'll see on the right, very high level strategic plans, 20 years in length, high-level themes, major allocations, sites for hundreds of houses, not to say even a new garden village will be in that kind of plan, through medium-level plans down to neighbourhood plans, which will cover small areas, perhaps parishes, and small sites. The process of bringing these plans into adoption will be constantly updating and constantly evolving as circumstances change, for example, demographics, population stats. So for a local plan to be adopted in your area, an evidence base will have been compiled, a draft will have been consulted on, perhaps as local residents or as the society will have commented on that draft. The draft will be revised, it'll be put out to public inquiry, there'll be modifications arising from that, and then the plan's finally adopted. And to have a look at an example of a local plan, here's Cheshire East's high-level strategic plan, 2010 to 2030. And in the middle column, it's probably a bit too blurred for you to read, but in the middle column is a general strategic or thematic policy that applies to all development, and it protects green infrastructure. So within it, it says that footpaths, cycle routes, greenways be safeguarded, augmented, and wherever appropriate, funded by developer contributions. So that's very useful to us. In the right-hand column is a site-specific and allocation policy. It's allocating former agricultural land at Heathfield Farm, Wilmslow, to be developed for 150 dwellings. But it's providing that the developers provide direct cycle and pedestrian links from the site to the west and improve links to a Summerfields local centre and to Wilmslow town centre and railway station. And the developer must also retain the public footpath crossing the site. So you can see that this local plan is doing a good job of both protecting and enhancing footpaths, both at a thematic level and also at the site-specific level. So moving on from planning's strategic approach to footpaths, I'm going to look at planning applications themselves into detail. It might help to have in mind an application for, say, 100 houses coming in on former agricultural land. So a planning application, when it comes in, is going to be registered on the website, given a number, allocated to a planning case officer. It's going to be publicised according to statutory regulations and also the council's own statement of community involvement, which we'll look at next. And how it's publicised, site notice, adjoining neighbours, letters, newspaper advert, that all depends on the size and type of the application. Consultees are given at least 14 days to comment, and the target for decisions is between either 8 or 13 weeks, depending on the size of the application and its complexity. But those deadlines are often extended by agreement. When the consultation responses, which could include ours, are in, the case officer will draw everything together in a report, and that's going to describe the site and its planning history. It's going to describe the proposed development and its impacts, all the consultation responses received from local residents to statutory consultees, It's going to explain what development plan policy applies, like those two we just looked at on the preceding slides. And it's going to set out any other material considerations. The report's also going to consider any conditions or planning obligations which might be attached to a permission, both to control the development and to mitigate any adverse impacts. And the report's going to conclude with a recommendation either to refuse permission or to grant it, subject to conditions and maybe to a planning agreement. So how's the decision taken? Well, for the smaller applications, and this accounts for over 90% of most councils in TRE, those minor applications are going to be delegated for decision by a senior planning officer. So he or she will read the report and come to a decision just sitting at their desk, and then the decision notice will be published on the website. But for major developments, say many hundreds of houses, they'll be decided by a planning committee made up of elected councillors. So in that case, the report and the plans will be published on a council agenda with at least 5 clear days notice for the public to read these documents. Maybe the planning councillors will go on a site visit and they'll take their decision at a public meeting, which anyone can attend. And each application is usually given a short period for public speaking at the beginning. Public speakers, having spoken, may be asked questions by the councillors. So these can be very lengthy proceedings and very volatile and hard fought. After a decision, how can it be challenged? Well, if the council refused planning permission and the applicant thinks that that refusal was unmerited, then they can appeal to the Secretary of State, who will ask an inspector to reconsider the application. And they'll do that either by a public inquiry or by an informal hearing, or they might consider that they can examine the issues and decide just on an exchange of written refs. If, on the other hand, the council approved planning permission and an aggrieved party thinks that the decision was flawed in some way, then their avenue is by way of judicial review to the High Court, a very expensive route to go down. And a judge will review the way the decision was made, what was taken into account, what was not taken into account, whether the procedure was correct. And if he considers that the approval was flawed, he'll quash the planning permission. So the developer would have to, if he wants to try again, go back to the beginning. So there are several stages there at which we could intervene. Before a planning application gets to committee, once we've read it, we could contact the applicant and perhaps suggest a redesign or some amendments if we think improvements could be made. Or we could and make our points to them and ask them to see if the design could be amended. We could write a letter of objection within our 14 days for comment, or we could write in requesting conditions or amendments. If we're not satisfied with the recommendation in the report, we could attend committee and one of our members could take part in the public speaking. If it goes to an inquiry, we could attend the inquiry and do the same. So there's plenty of opportunity there for the society to take part in the planning decision process. I'm going to gloss through types of planning applications, but we could come back to this if anybody has a question to ask about it, because it is pretty detailed. And I know that the consultation of planning applications is a subject dear to Terry's heart, so I'll spend time on this instead. So how do we get to know about planning applications? Well, the regs say that developers must use standard forms available on the planning portal. There's an extract from one to the right of the slide. And fourth question down is, are there any new public rights of way to be provided within or adjacent to the site? And below that, do the proposals require any diversions, extinguishments, and/or creations of rights of way? And if the developer answers yes to either of those questions, then he has to show the detail on his plans. And by regulation 15 of those, that order, the council then has to publicise the planning application, not just by site display or on its website, it has to publicise it by press notice in a local newspaper. So those are the statutory requirements, but there are some discretionary steps that might be taken as well. So in addition to their duties under the regulations, councils can take further steps if they wish to inform communities and other interested parties about planning applications, and they have to publish these steps in a document called a Statement of Community Involvement. And there's Cheshire East in the middle of the page and an extract from it on the right. So it lists non-statutory consultees. These are bodies which it may consult if it considers that the body would be affected by what's proposed in a planning application. So they don't have to do this, they may. And in that list, when you get down to E, is included East Ramblers, and at F, Footpath Preservation Societies. So when you get to P, I'm afraid Peak and Northern Footpaths are not mentioned, but will come within that footpath preservation societies. Now, my experience in Cheshire East actually is that I don't think Peak and Northern were consulted. East Cheshire Ramblers were, and perhaps smaller footpath groups operating in the districts might have been consulted. So it's pretty hit and miss. And a question which Terry is going to address is how can we get involved in being more productive consultees when the requirements to contact us and the requirements about a press notice make it really difficult for us to find out what's going on. I'm going to gloss through the detail on planning decisions because I think it would be good to spend some time on an actual practical example of a planning application and determination in practice. So you can see in the bottom left-hand corner a plan of an area of land, and this is a site south of Sandbach, a greenfield site, and the site is located just to the right or east of bypass and to the left or west of existing housing. You can see there's a footpath which is 19 running up the left there, and running down the right is footpath number 18. I'm going to ignore footpath 17 because it didn't feature greatly in the application. The planning development that was suggested was for 85 houses, a new spine road. If you can see my cursor, the houses are to the south of the site here. The care home is here. The spine road is a new spur coming off that roundabout there. There's going to be a new food store, a Lidl, over here. And then the rest of these commercial buildings are petrol station, shops, and a couple of drive-throughs. A significant aspect is that the existing was a slope down towards the bypass. But in order to provide the platforms for these commercial buildings, the developer was going to reprofile the site, creating it into more of a U shape. Now, the footpaths are shown in purple here. And footpath number 19 to be brought more into the middle of the site and to run along the spine road. And footpath 18 was going to stay on its line, but it was going to be now, its line would now be sitting on quite a high embankment because of the U shape that was going to be created for those commercial buildings to sit in. This was a very, very contentious application. Objections flooded in. And with regard to footpaths, there were objections from the Open Space Society, Sandbach Footpath Society, the Council's own Public Rights of Way unit, Town Council and residents. And the Council refused it on 6 grounds, including harmful impact on the 2 Public Rights of Way, 18 and 19. And in August 2020, a 7-day inquiry was held. It was one of the first inquiries in the country to be held via Zoom. Lots of consultants arguing their case, barristers, the developers had QC. And the end and the rest of that side are listed, and the benefits in favour of the scheme listed or as discussed by the planning inspector. So these are taken from his decision letter, and you can see there are many benefits. There was already an existing mission for 200 houses on the site. The highway design, traffic generation, parking proposals, all up to standard. There were social benefits. We need housing, we need affordable housing, we need care homes. Economic benefits, those new residents are going to be spending money in Sandbach Town Centre, which is going to improve its vitality and viability. Heritage benefits, there was a farmhouse dating from 1800 in the middle of the site, and that was going to be retained and renovated. That site was an accessible distance from the town centre by cycle and foot. The biodiversity and ecology mitigation measures were all acceptable. And the proposals for the open space that was going to be provided, children's play areas, trees retained and planted, air quality, light pollution, impact on existing adjacent residents. Over 7 days, they were all examined and all found satisfactory. But there were 2 things that the inspector didn't like. He thought that the commercial development to the north of the site was poorly designed, and that the reprofiling of the landscape there, the U shape that was going to be created, that was excessive, and that it went against the grain of the site topography, and that was going to cause substantial harm. He also thought that unacceptable, unpleasant urban character change to footpaths 18 and 19, not through the housing part of the site, but through the commercial north of the site, moderate harm. And so, although you can see that the benefits were great in number, the inspector felt that the harm was greater in weight. And so, for those two reasons, he refused the planning application. So, footpaths taking a major part in the inquiry and forming part of the planning refusal. And just to highlight a couple of his comments about the footpaths. Footpath 19, that was the one that was going to travel along the Spine Road. It was something of an avenue, it was going to be tree-lined. The inspector noted that state road footpaths, they're not encouraged, but nor are they precluded. But nonetheless, you would be walking along a road now dominated by vehicular traffic, parking, engineered structures, commercial buildings. His strongest objection, though, was to footpath 18. You remember that's the one that was staying high up on the embankment. Well, that was going to be running behind the new food store. And he thought that pedestrians were going to feel hemmed in between safety fencing and building, and they'd be in an uncomfortable, over-engineered environment. So a very interesting planning decision for those interested in footpaths. Moving on to another example, this time connected to the Equality Act 2010. When councils take planning decisions, they have to take them with the public sector equality duty in mind. And that means they have to pay due regard to the need to advance equality of opportunity for people disadvantaged on grounds including age and disability. There are 9 grounds in all. These are the ones I think you see most often quoted in the planning sphere. And if you can see the picture on the right there, that's the River Mersey to the right. If you can see 2 semicircular shapes, they are a car park at a stretch of the PROM called Alabama Way, which is in Seacombe, and the Wirral Circular Trail runs along the PROM there. And before the planning application, this car park was well used by disabled people driving down, parking there, and you can see what excellent short, quick access they've got out of the vehicles, and they're immediately on flat ground right next to the PROM. So a planning inspector had granted permission for officers in place of the car park, but an application for judicial review went to the High Court, and having examined the evidence, the judges felt that though the able-bodied would still be able to use the Wirral Circular Trail with just a short 40-metre detour around the new officers, the disabled would have to park some distance away, and that they'd struggle to reach the PROM via a strict path down. The judges felt that the inspector had failed to take the particular impact on the disabled into account, and so the planning permission was quashed. Another good example. I'm going to gloss over the slide about planning conditions to keep within time. Perhaps all you need to know is that we might be writing consultation responses into a council saying, if you grant permission for this, please would you attach a condition upgrading, say, an existing footpath surface that runs through the site so that it can withstand the extra footfall. Or we might be saying, You've granted permission at outline stage in principle, but when the detailed layout plans come in, please make sure that they show that they follow routes which avoid estate roads, which lie through open corridors and open spaces, which link to public open space, a bus stop, a highway off-site. Or we might be asking for a condition delaying development on site until something happens off-site, like phase 2 shan't commence until a footpath diversion order has been determined, or no more than 50% of the dwellings on site shall be constructed until a new footpath link has been provided from X to Y. On to money and planning obligations. So, planning permission can be granted subject to the landowner or developer having to enter into an agreement, or perhaps they've offered an undertaking whereby money is paid to planning authority to be spent on mitigation works. For that to happen, the works have to be within the council's control and they have to be necessitated by the new development. So an obligation might read something like, before a particular date or event, pay X £1,000 to the local council to be spent within 5 years on works to upgrade the ABC trail between points X and Y. You might even be able to refer to a specification for those works. Now, David has had some success with planning obligations, obtaining money and improvements. So I'm going to stop screen sharing. Am I David? Or are you just going to?
No, I'll just talk to your slides, please.
Join in.
Yep. Can you hear me?
Explain these slides.
Right.
Okay.
So I was involved with this area. I've been the chair of the Friends of Merley's Fields for a number of years. And you can see here, these are the existing triangle of footpaths on this area known as Merley's Fields. This was originally the sports fields for the Merley's Blackstone factory that was on this site here. It's now MAN, Energy Services, and these are the new housing. Now, when the application came in for these houses here, about 200 units, it included what's called a transport plan, which was to show that people could go by foot or by cycle to the railway station, which is here, Woodsmore Station, or they could cross the fields here to access other facilities here across the fields. Now, the Friends group pointed out, Beacon Northern were not involved as far as I know, but the Friends group pointed out that the transport plan was totally unrealistic. First of all, this route here was extremely dark. In fact, Sheila, if you can move down, I'll move to the next page. Thank you. So, yeah, sorry, the one before that. The one before. Yeah, there we are. So this is the track that goes to the station, and it's quite overgrown, as you can see. This is how it was before the works were done, and it was unlit. And in the winter, we argued that people would not wish to walk to the station while the path remained in that condition, and therefore, as a condition of granting the planning application, the surface should be improved and that lighting should be added. And indeed, that was agreed and it became a section 106 that the developers would need to put in a new surface, and although you can't see it, there are lights all the way along this section of track, which is now dual use for walkers and cyclists. And if we just go down to the next one, Sheila, this is the path that crosses the fields, and this is how it was for much of the year. This was an absolute quagmire, and nobody could walk their children to school through mud like that. So we made this point, and it was accepted, and this lovely new path was built across the fields, which is an all-weather footpath. And I have to say that since that was put in, we've had many more people walking across the fields than we ever had before. So it has definitely increased public usage.
The second way in which money might come out of development for public rights of way, I'd looked at 106 obligations. So CIL, or Community Infrastructure Levy, came in 2010, but I don't think that our society or small communities, or any small community projects are yet seeing much money come out of this yet. The idea is that a council will quantify the amount of new development it's allocated. It'll quantify the viability of the sites and the net profit that's going to come out of them. It'll also quantify the cost of new infrastructure it's going to need because of the development. So it'll look at what the impact on its leisure centres, its cemeteries, its highways, including footpaths, what that impact will be, and it will proportion the infrastructure costs between the amount of development coming forward. So if, for example, a developer wants to provide new housing in Knutsford, he will get a CIL bill of £57 per square metres of new development in that area. And the equations will be different from affluent areas like Knutsford with high land values to less affluent areas which might have a £0 levy. Having got the money, they can then spend it providing or repairing infrastructure needed to support the development. And public rights of way is green infrastructure, so it will qualify for that money. As well as spending the money itself, a council, an LPA, is obliged to give either 15 or 25% of it to town or parish councils in whose area the development's going to happen, for them to spend that money on infrastructure. So in the middle of the slide is just the front sheet of Cheshire East's annual infrastructure funding statement, and that tells the public how much it got in from CIL in the previous year, what it spent it on, and what its spending plans are for future years. So drilling down into that, there's a paragraph which explains on the right, it's going to be spending CIL on schemes of infrastructure provision or improvement to schools, nurseries, roads, leisure centres, cemeteries, waste recycling centres, gypsy and traveller sites, heritage assets, car parks and public rights of way, as are listed in the council's medium-term financial strategy. And when you look in that document, you can see named projects upon which the council will spend CIL and other money it gets in, say, government grants. And for example, one of those projects, which will be close to David's heart, is £100,000 is going to be spent on public rights of way compensation mitigation measures at the Manchester Airport Relief Road scheme, which crosses the A6 up near Stockport. So there is hopefully an opportunity there with SIL. I don't see it happening at grassroots level yet, but the opportunity's there in theory to partner up with town and parish councils, because they'll be getting some of these SIL receipts, and they may be open to match fund, I would think, some community footpath projects. So that was the end.
Thank you, Sheila. That was most interesting and informative. Now we're going to go to Terry Norris, who many of you will know. He's going to be talking about how we in Peak and Northern can respond to planning and planning applications. Over to you, Terry.
We covered this in the first part to a large degree, but let me just run over it again, because it's so important. There's no duty on a local planning authority to consult the society when the application's made, even if there's an effect on a right of way. Now, all local planning authorities, as Sheila said, have to publish online a searchable list of applications. Now, I want to explain why that doesn't actually help us, because the thing is, it's just a list that tells you what the development is and what the number is, but there's no way you can discover if there's any effect on a right of way without actually looking at the application form and looking at the answer to that question that Sheila put on the screen about rights of way. And there's several problems with that. Firstly, in most cases, there isn't any effect. There's no rights of way involved at all. So you'd spend a long time for very little gain. And anyway, the answers are often inaccurate or even downright lies. The developer sometimes seems to think that they just don't mention it, then it will go away. So that's an extremely unsatisfactory way of dealing with things. Now, fortunately, this Development Procedure England order does specify some basic publicity requirements, which are potentially very useful for us. So there has to be this site notices and notices in a local paper. Now, these are the bits that probably nobody reads unless you're a very peculiar person. It's the public notices. They're usually in free papers because they've got the cheapest advertising rates. Things like the Stockport Express, the Tameside Reporter. Yeah. Now, what we need to be able to do is to monitor notices to identify the applications where a PROW is involved. So we need to look at these and to pick up the Article 15 ones that apply, because it also applies to listed buildings in conservation areas. It's a similar obligation. You can obviously just ignore that and focus on the ones involving PROWs. Right, next slide, please. Yeah, so now I'm the consultations manager at the moment, although I'm retiring at the AGM. So I go to Taylor House and been going for some time with a team of assessors, which at the moment is, well, it's getting bigger actually by the moment, which is good, but it's basically been Brian and I for some time. So what an assessor does in Taylor House, and this is what the AO will do in their parishes, well, to look at the planning documents online. Now, they're usually, this is very well organised actually. So the problem is the amount of material that you get. Now, if it's a simple householder application, like somebody who wants to build a single dwelling or an extension to their house, then that's relatively straightforward, and anybody can really handle that without much experience. You get probably up to 6 documents. But if you've got one of these really big developments, and I mean hundreds or even thousands of houses, then you're going to get hundreds of documents online. And to actually, find out which one is pertinent is a skill, and it can be acquired, and that's what we want assessors to be able to do. And then that person then has to extract the information about the right-of-way to send to the inspector, because we can't expect inspectors to do that. That isn't why they became inspectors with the society. And in fact, they would, I think, would be quite reasonably resistant to expecting that. But so it's up to us to present a briefing paper which sets out what the application says about rights of way, what the intentions are, or if there isn't any intention to do anything about it, what could happen to improve the paths. We send that to the inspector along with a checklist which draws the attention to the sort of pertinent factors which would be relevant if later on there's an argument about an order. And the inspector is asked to report after a site visit, because we need to find somebody who knows the paths around the site and can say sensible things about it in line with the request statement that's been sent to them. And that works quite well in some areas. Now, the problem is, though, that we have a large number of parishes where we don't have inspectors. And then we're always looking for people who will do this, who live reasonably close or will travel to the area to look and then to make a report. And we would like to develop a team of people to do that sort of thing. I mean, one of the problems is that there's no obligation to show the line of the right of way in the application documents, and particularly in the site plan. Now, it's not a huge problem because you can work it out from our Forts information database, but it means sort of transferring the information across. And it's quite clumsy and it's very irritating. They used to show rights of way, but in most cases that they're not shown. So there's a bit of map work to be done. Right, so what should be the approach then? Well, when the inspector looks at this, then the basic idea is the development should be planned around the existing rights of way. That's what planning policy says. It's been quoted in several documents tonight. If that's not possible, then how can the path be diverted or moved to benefit walkers? It's best to try and anticipate that if that is the case, and then make some sensible suggestions. How can there be links to other rights of way or routes to local amenities, like schools, railway stations, the local shops, library, and so forth? And that's, again, consistent with national planning policy and local plans. So the FID, that's the Forts Information Database, may well be very helpful in this exercise to the inspector, because it shows the line of the path, and there may well be comments on the condition of the path. And that enables, again, it could be a good source for things to suggest to improve matters, particularly if they're in poor condition. So let's look at some examples of PNFS representations. So the next slide, David, please. Right, first one. These are all actual examples that I've been involved in where I was the assessor or an inspector and made direct representations to the local planning authority. So the first case was one where there was support for a proposed improvement of existing rights of way on a development site and replacement of stiles with gates. This was an excellent one where the developer, the architect, was very keen to do these things and suggested it, put it in the original planning document. So that was greeted with great enthusiasm by me on behalf of the society, because it is important, I think, to be as positive as possible when you can do that, because then they tend to look at the society in future and think, oh, they said nice things about that, and let's contact them about another one. Because it would be really good sometimes if the developers contacted us before they even put in the planning application. And the perfect world would be to actually go walk around the site with the developer and talk about what the possibilities are. Now, I have succeeded in doing that in some cases in Kirklees, and it's been very, very rewarding. So be positive when you can. Secondly, proposed diversion and erection of a bridge to avoid part of a development site crossed by heavy goods vehicles. And this suggestion was adopted by the local planning authority, and the developers themselves were keen to do this because they didn't want problems with sort of pedestrian vehicle conflict. They realised that it would be totally impossible because it was quite a well-walked area. So that, again, was a success story. Then a very different one, an application for a single dwelling a right-of-way crossed the proposed parking area and it was obstructed. Now, if planning permission had been granted, the path would in effect have been lost to the public. There was a stile leading to the beginning of the path, going down into the site which was planned for development, and it was completely blocked. A very unpleasant landowner, and we'd had problems with him over every path on his land for years. So the local planning authority and the rights of way staff were notified about the obstruction. And then I brought in the Courts and Inquiries Officer, Andy Leader, who sent a letter before action to the council saying that we're going to serve a section 130A notice if the matter is not resolved. Now, this section 130A notice, what that means is it says, you test to the council, you're under a legal duty to see that obstructions are removed on rights of way, and you've got so many weeks to do it. And if you don't do it, then we'll go to the magistrate's court and ask for an order. We've never had to do that because the notice itself, even the letter before action, actually generally results in something positive happening. Now, in this case, nothing is happening, and it's still, we might well have to go to the next stage. But that's important that we involve Courts and Inquiries Officer in enforcement when it's going to be such disastrous consequences if this is not sorted out. The next one was an application for housing in Green Belt. This was in somewhere called Denby Dale. There was great local opposition to this. So the developers, one of the reasons to try and get around that was to offer a path along the riverside. And that was welcomed by all, and planning permission was granted. So next slide, David. Now then, something which is quite common, when developers get their planning permission, but they don't really like section 108, the planning obligation, or something about they want to have another go, or they want to sell it on to somebody else to develop, and it would be better if they could get rid of that. So the developer then applies to have this condition for creation of the river path removed. And he gets a report from consultants who claim, amazingly, that's just what they said. Right. It is irrefutable that ill-conceived footpaths are the main generators of crime. They provide access to commit offences and a choice of escape routes. I mean, I think actually if you pay consultants enough, they'll say anything you want. The author states, as an adult male, he would not choose to walk along such a feature, and nor would he wish any member of his family to use it. Such are the risks and likely fear of crime issues. And I said, as for the fears for this women folk, I hesitate to mention them, for fear of causing widespread panic should the path ever be provided. The developers have the support of Councillor Dodds. Now, you do get these antediluvian councillors who seem to emerge from the shadows and make the most reactionary, unhelpful comments you've ever heard. Councillor Dodds deserves a prize for that sort of thing. Anyway, he sits on Kirklees Council. He's expressed fears that the riverside path will attract unsavoury characters and create opportunities for crime. Denby Dale it's a very high-class residential area where housing is extremely expensive. It's a middle-class sort of suburban dormitory, really, for Huddersfield, part of Huddersfield. Anyway, he refers to a recent armed robbery at a supermarket in Denby Dale and a spate of cars being broken into, including his own. As these crimes took place on roads or were committed having obtained access from a road, then we can now expect his cause for all the roads in Denby Dale to be closed. At this point, I think the officials giggled to themselves at the meeting, because I asked this to be read aloud at the meeting, because officers, what they can never do is to be rude or obstructive to councillors. They've got to be endlessly polite. So I think they got great vicarious enjoyment by seeing him wriggling. Yeah. And then my real cri de coeur, because I really do believe the next bit. One approach to feeling safe in a rural residential area is to live in a gated estate, closing off all public access. This is a policy of despair. Rather, as a community, we should value and cherish our villages with their ancient network of footpaths, alleys and ginnels. Regular usage of such ways by respectable folk, young and old, can deter would-be miscreants by providing natural surveillance and supervision. And I quote that actually from an assistant chief constable in Somerset that I read when he said that in the Guardian years ago. There aren't many Guardian readers amongst the police, perhaps. Anyway, the developers accepted the condition requiring the provision of the riverside path in part to persuade the planning authority to grant planning consent for what will be a very lucrative project. It was imposed for a good reason, which is just as valid today as it was then. The council must stand firm. Unfortunately, they did. So I was quite pleased with that. I enjoyed myself writing that. Yeah. Right, next slide. So, making the society more effective. How can we make a better job of things? Well, firstly, we need to be proactive. We can't wait until the statutory consultation on the public path order to divert or extinguish the path. That really does not work. It's hiding to nothing. And we keep, every so often we get sort of letters saying, why didn't we do something about so-and-so? Have you seen what the developers have done? And then we look back to our files and find, we weren't notified about the path. We didn't know about it. We didn't know about the planning application. So the whole thing, is a mess. So we need to monitor Article 15 notices online. Fortunately, most of these local papers do have websites, and it's possible to get a link and to check that all the notices tend to appear on one day of the week. So, I monitor Tameside from that point of view, and every Thursday the notices appear. And it's a pretty small number, so it's handleable. We need to obtain a report from an inspector who has seen the site. You can't really comment on these things unless you've got first-hand knowledge. It's very dangerous to sit down and just spread out lots of plans and then try and say sensible things. You do need to rely on this first-hand knowledge, which inspectors either have or can acquire by going out and doing a site visit. We need an increased number of assessors at Taylor House, or they could work remotely. That's perfectly possible in this area. The task really is in preparing a summary of the proposed changes to looking at the planning documents and making sense of what's going to happen to the paths and making sensible suggestions. Well, after you get the inspector's report, seeing what can be done. But the inspector needs to know, he wants a summary, he or she wants a summary and wants a checklist of relevant factors. And that's the big task, which we cannot do at the moment. We would like to extend the number of councils that we monitor their planning applications. So at the moment, we only really do a handful, and we could do more. I've been in contact with some councils who are quite willing to send us a list, actually, which is pleasing. But we need to be able to be guaranteed to have some sort of response. So we're looking for extra volunteers to get involved in this. An ideal person would be a retired planning officer who's a keen walker. Such a person would almost do anything to get one of those. We need to work with affiliated societies to share information on applications of concern so that we can tip them off, they can tip us off when there's something coming up. They'll be in contact with local affairs. We've got a lot of affiliates. This is an undeveloped area of our work in the society, making most of that resource. So that can work very well potentially. But at the end of the day, we must be prepared to oppose unsatisfactory public path orders which flout national or local planning policies. So these will be ones where we've made representations which are rationally based on proper planning documents, and the council or the local planning authority is resistant. Then we've got to be prepared to oppose that, just like we do on unsatisfactory diversions and most extinguishments under the Highways Act. We've got to get involved in these other cases as well, where there is a reasonably good argument. And there's one at the moment that Andy is fighting in Holme Firth, which is going to be hopefully get a lot of publicity in our journal if and when we win. Because the local planning authority cannot confirm an opposed order. So as soon as we say we're going to oppose this, that creates great difficulties for everybody, because it holds everything up, and delay means, loss of money. So developers don't like that. I have been known, to ring up developers and they say, "Hello, who are you?" And I say, "I'm Trouble." And they say, "What do you mean you're Trouble?" And then I explain to them about confirming orders and so forth. And then they tend to listen, or even to invite to meet on the site so that we can try and get something out that's more satisfactory. That's only in extremis. It's not a recommended thing to do, but can be quite satisfying. Yeah, the other thing we need to keep an eye on is all these planning policy documents that are coming out. I know they're full of greenwash and they're not the most interesting things to read, but they are important because we need to be able to quote them wherever possible to support our case. And they do actually, say the sort of things that we would want them to say. It's just making them a reality on the ground. Yeah. So whenever we get these things, we need to take them seriously and look at them and put forward the society's point of view and secure satisfactory amendments. Right, David, final points. Yeah. Now, developers make vast profits. If you look at the bonuses that have been reported in the paper recently, they're millions. Developers are making vast profits. And most of these houses are buy to let, and the tenants having to pay enormous amounts of money for rent so that they can't ever get on the housing ladder themselves. It's not just in London that's a problem. It's a problem in Manchester and in other areas within Peak and Northern's area. So let's worry about the developers having to pay for things. They can afford it. Yeah. So the costs of improving PROWs as part of a development project are negligible compared with many Section 106 obligations. We're not asking for a roundabout or a new road or a school. What we're asking for is at most probably a few £1,000s to improve a path or to make a new path that's safe and easy to use. Yeah, so it's really peanuts in terms of the things that sometimes are quite reasonably asked for. Yeah, there's no effective taxation of the increased value of land as a result of the grant of planning permission. And my goodness, the increase in value is immense. And that's not taxed properly or taxed at all. So there's a lot to go at. And planning's a threat to everything we want to see about rights of way, but it's also an opportunity to make things much better in the interest of the community.
Well, thank you, Sheila and Terry, for informative and also inspiring talk. You've managed to make a very complex topic comprehensible. I think it only remains for me to appeal to those of you in the audience or watching this video to come forward to see if you can help Peak and Northern protecting footpaths as we do. If you're interested in helping us with monitoring planning applications, then please do get in touch and we can all put our efforts together to try to protect the rights of way network as best we can. So thank you everybody and good night.